science and the use of scientific technologies in crime investigation. That will be our primary focus of the discussion. So let us start. I'll share my slide. Can you just allow me to share my slide? Because
yes, sure.
Yeah, sure. Okay, now I can present. Thank you. Yes, I think it is visible, right?
Oh, yes, ma'am, it's visible.
Okay, let us start. So, the learning outcome of this particular lecture will be to understand what is the role of forensic science in legal practice, basically, and to explore the application of criminal investigation, explore the application of forensic science in investigation, courtroom, and legal outcomes. What are the legal outcome of using forensic techniques? And legal frame, as I have already told you, the analyzing of legal framework surrounding forensic science in India. And then we will be discussing the prospects and the challenges arising due to the implementation of new criminal laws, especially Bharatiya Sakshi Adhiniyam and BNSS, Bharatiya Nagarika Suraksha Sanstha. Okay. So first of all, when we are discussing about forensic science, we have to know what is mean by forensic science, how law is intersecting with the science. Basically, this is one of the area where law is intersecting with the science. So if we see the etymological meaning of forensic science, the term forensic, basically it came from a Latin word forum. Forum means assembly. So initially, previously, the crime adjudication, which was happening in a different way rather than the current criminal adjudication or the court proceeding. Especially in Roman Empire, when there is a case which has to be decided, all the local people of that particular locality, they will assemble in a particular place. That place is called assembly or forum. So in that particular place, both the victim or accused or both the parties of the case, they will be narrating their own side. So based on that narration, which is having more reliability and more substantive and which is having evidences, the people will believe that particular narrative and the case will decide, or the adjudication will be in favor of the person who has given the better narrative. So that was the initial criminal adjudication process. So that particular place was called forum. And then we have taken that word forum for the purpose of forensic science also. And the next, science, or you all might be knowing the meaning of the science and how we are using science in the field of criminal investigation. Basically, we will be using scientific method for collecting, identifying, extracting, analyzing the evidences, different kind of evidences. For all these purposes, we will be using scientific method. And what is mean by scientific method? Scientific method include basically 3 steps. First thing, you will be observing a particular phenomena. It might be a natural phenomena, or you might be observing a particular thing. And then the second stage is you will be experimenting. You will experiment whether how this natural phenomena has happened, can be created. Lot of experiment you will be doing. And the next stage is repeating that experiment again and again. So here also, if we include these 3 steps for identifying or collecting or producing evidence before court of law, then that is known as forensic science. Basically using all the scientific method for producing evidence before court of law. This is what mean by forensic science. So here, since we are using only scientific method, the significance of using scientific method is it will give you objective result, right? It will not be having an element of subjectivism. Since it is giving objective information, that will be more reliable in nature. But unfortunately, our legal system still having still giving more prevalence for subjective informations like oral testimony, witness testimony. We are giving more reliance for that. Sometime when there is a testimony of expert, a forensic expert, his like evidence, most of the time court is having a tendency to rely more on an eyewitness testimony. That might be that one of the reason for that might be the non-accuracy or the way we are exercising the evidence collection through forensic method, that might not be accurate enough, not enough. That might be one of the reasons for giving heavy reliance on oral testimonies. We will be discussing about the problems of that in subsequent slides. Okay. Now let us see how forensic science has been used in legal practices. As I have already mentioned, different forensic aids. Forensic science has different variants, like ballistic is there, fingerprinting is there, and all the forensic science lab will be having their physics division, chemistry division, biological division. So all this aids we are using only for the purpose of gathering evidence, and ultimately it will ensure justice. And evidence collection and preservation. Collection and preservation will also have the use of scientific methods. And there is a fundamental principle in forensic science. All you must have heard about Lockhart, Edmund Lockhart. He had enacted a particular principle, that is principle of mutual exchange. This particular principle we are using in crime scene investigation. Whenever the investigation officer is collecting any kind of evidences from the crime scene, he will be having this principle in his mind that whenever two people are in contact, they will leave some kind of traces. So whenever a particular victim or accused is present at the crime scene, if there is a possibility of leaving certain evidences there. For example, hair strips or fingerprint or body fluids, maybe dress or food mark, anything can be left in the crime scene. So it is the duty of investigation officer and forensic expert to collect and preserve that particular evidence they are getting from the crime scene. And the preservation will be having another significance, because most of the time courts are not relying on the forensic evidence by challenging the process they have collected the evidence, by the process they have preserved the evidence. If I can give an example, there was a case of this is a hypothetical situation, and there is a case of rape. The investigation officer, he has collected, he was having some of the evidences, some of the clothes which was worn by the victim and the accused at that point in time, and he got that from the crime scene. And he collected those dresses of both the victim and accused, and it was having some body fluids like semen, blood stains, all were there in the dress. And after collecting that, he has mixed that both the dress he has packed together, and he sent that for the forensic examination. So here the result was not accurate. He has the forensic. Is there any doubt? May I continue?
Ma'am, could you repeat the principle that you talked about, the name of the principle?
Yeah, sure. That is Lockhart principle. Lockhart's mutual exchange principle. Principle of mutual exchange.
Bolo.
Yeah. That means whenever there are two objects or two people, whatever it is there in contact, they will leave some traces. This is the fundamental principle of crime scene investigation. You can just imagine, I think, when there is a crime which has happened, there is always a possibility they will leave some traces, right? It is impossible. That might be very micro in nature, but it is impossible to escape from that particular place if they are in the contact without leaving any traces. Is it clear? I think
Yes,
I
ma'am,
can,
yes.
yeah, I can discuss the another principle. That is, I was discussing it with an example, the principle of analysis. Most of the time, the court will not be relying on the forensic evidence by saying that the way you have collected the evidence is not proper. The way you have preserved the evidences is not proper. So if the reason for not relying on those kind of evidences is it will not give an accurate result. This is known as principle of analysis. Whatever you are analyzing, you will be getting a result according to the evidence you have given, according to the material you have analyzed. If the material is not having the qualitative, it is not having the quality enough, then the result will be wrong. So it is always important for the investigation officer or forensic examiners to follow certain procedure, protocols before collecting the evidence. So, but unfortunately, we don't have a fixed guideline for that. According to the state and jurisdiction, it varies. Yes. Now I think I can, yeah. Now let us have discussion with respect to expert testimony in courts. Generally, in Indian Evidence Act or Bharatiya Sakshi Adhiniyam, only like the evidences of eyewitnesses or the accused or the witness will be taken into consideration. But in certain situations, third person's testimony will also be having relevance. One of the situation is expert testimony. If a person is expert, then he can give testimony before the court, and the court will consider that as relevant. We will be discussing about that also in subsequent. Now, first, let us discuss about how forensic science is having a significance in CRPC or Bharatiya Nagarika Suraksha Sanhita. The Bharatiya Nagarika Suraksha Sanhita has replaced CRPC. All of you might be knowing about that. And one of the intention of the new enactment BNSS was to include more advanced scientific technologies and use forensic aids, forensic technologies in criminal investigation. That was one of the intention of enacting new BNSS. But initially, if you examine the provisions of the CRPC, there also you will be able to find out different provisions where we are using forensic techniques. For example, section 53, 53A, 164A, there the magistrate will allow investigation officer or the forensic expert to examine both the victims and the accused person's biological samples, handwriting, fingerprints, and then DNA analysis. Anything can be done by using this provisions. Magistrate will allow investigation officer to gather this evidence from the accused person or victim. And the same is there in the BNSS as well. In BNSS, this is one of the very significant change. Actually, we have introduced a section 176 clause 3. This was not initially there in the CRPC, which is almost corresponding with the section 157 of CRPC. And this 176 clause 3 of BNSS, which has introduced a new mandate for collecting forensic evidences from the crime scene. So, if there is an offense which is punishable for 7 years or more than 7 years, it is mandatory. Now it is mandatory on the investigation officer that he has to take the aid or assistance of forensic expert for collecting this evidence. That means without having the help, without the presence of forensic expert in the crime scene, it will not be possible for the investigation officer to collect evidences from the crime scene. So this is one of the very significant change. Here, if you examine the section, you will be able to find out it will not be getting implemented immediately. They have given a 5-year cooling period for implementing this provision, because if you analyze some of the statistics, that we are using we are using forensic evidences or for aid of forensic expert only in 20% of the criminal cases. So substantial criminal cases are not or investigation officers are not using forensic experts. So now when we are making it mandatory that for all the offenses of 7 years or more than 7 years, you have to use forensic expert. But it need a lot of infrastructure. So the implementation of that provision, this provision will be difficult immediately. That is the reason they have given a 5 year of cooling period. In this 5 year, the way state government can create infrastructure for implementing this provision, because we are not having that much forensic science lab or mobile forensic science unit for reaching immediately to the crime scene for all the crime scenes of 7 years or more than punishment offense. So it will be very difficult to implement this provision immediately. 5 year cooling period is there. Now, some of the significance of this provision was actually there was no uniform legal framework for crime scene management. Now also this crime scene management uniform procedure or statement of process is not there with regards to this. So every state will be doing their crime scene management according to their police manual or their specific rules. So it is necessary. This provision might lead to creation of a uniform statutory guidelines for crime scene management. That is one prospect of this particular provision. And it is this new section aimed to ensure proper forensic collection in serious cases. Serious cases means 7 years or more than 7 years. So this section is making it mandatory. So it will be more, the adjudication will be more accurate and reliable by using forensic evidence. And like existing forensic practices, all the existing forensic practices are varied according to different state jurisdiction. For the first time, the Karnataka has appointed civilian forensic expert for crime scene management. So after the incorporation of 176 clause 3, maybe every other state will also appoint similar forensic experts. So that will give a future perspective to the profession of forensic science as well, because we will be needing a lot of forensic experts for implementing this provision. And if you examine, they have not mentioned the forensic expert should be a registered forensic expert or it should be a government forensic expert. There is no such guidelines have given in the provision. So it is implied that both private and like government forensic expert can assist the investigation officer for crime scene management. And there are some implementation challenges. I have discussed that. Yes. But there are some challenges. When we have discussed about the prospect of 176 clause 3, there are some challenges as well. One of the challenges, as I have discussed, that this definition is very broad in nature, especially the term they have used is forensic expert. They have not mentioned whether it is government forensic expert or private forensic expert. If it is a private forensic expert, like we need certain regulatory oversight. Like in CRPC, they have mentioned about victims examination, rape victim examination. Rape victim examination can be done by a registered medical professional. So it can be a private registered medical professional as well. But that private registered medical professional will be regulated by National Medical Commission. They will be registering in that. But with respect to forensic expert, they have not mentioned anything with related to their body of education, licensing, and what professional standard they require. So it may cause serious concerns. This is one challenge of this particular provision. And another problem is allowing all the private forensic expert in crime scene examination without a monitoring body that will always create a confusion with regards to their expertise, proficiency, and ethical complaints. So these are some of the issues. And another issue is, as per this particular provision, it is mandatory forensic science experts should visit the crime scene, right? So there is always a possibility of bias, because when they are visiting the crime scene, they will be exposed to several irrelevant information. For example, if they are just in the forensic science laboratory, they will not be exposed to a lot of information regarding the crime. So here they might be exposed to confessions or witness statements. So all this may lead to a cognitive bias in their mind. So whenever they are examining the crime scene and analyzing the evidences in the forensic science laboratory, whatever they have heard or witnessed in the crime scene might get influence their analysis also. This is one of the concern. Another concern is infrastructural needs and workload pressure. Otherwise, also we are not having that much forensic science experts or forensic science labs. So without having those expertise or without having number of experts, it will be very difficult to ensure that every crimes of this nature will be getting the assistance. For that only we have given 5 years of cooling period. And without appointing sufficient forensic experts, the additional workload will be there in the existing forensic science expert. That will obviously result the deterioration, or it will not give very accurate or proper result if the workload has increased. Very general. Now, there is another provision in both CRPC as well as BNSS. Section 311A of CRPC, and which is corresponded with Section 349 of BNSS. Actually here, according to Section 311A of CRPC, here the magistrate can order that handwriting and signature can be collected from the accused person. Investigation officer can collect handwriting and signature according to 311A of CRPC from the accused. But when we have enacted BNSS, we have expanded the scope of 311A. Now it is possible under Section 349, it is very much possible to collect handwriting, signature, fingerprint, and voice sample. So they have expanded the scope of 311A. Signature, handwriting was already there, but now the investigation officer can collect fingerprint as well as voice sample. This may create certain concerns. We will discuss that. And another important change which had happened with respect to 311A was, initially it was not possible. It was possible to collect this kind of evidences from the previously arrested person with a connection with the investigation. But according to 349, now magistrate can order collection of sample from any person. But magistrate has to give the reason in writing. But you have to be mindful about this fact. Even if that person is not having any connection with the crime, then also the magistrate can order for collecting this kind of evidences, samples from the person. This will also cause a serious concern. Okay, because here which has specifically mentioned, there is no requirement for establishing either the person's connection with the offense or the relevance of their sample or criminal investigation. So with respect to fingerprint examination, you might be thinking that it is very much advanced in nature. Actually, there are several studies which had conducted in the year of 2011 and 2014. It has shown the false positive rate in fingerprint examination is very high. Like if we do around 306 fingerprint examination, there is a possibility of 1 result will be false positive. And in 2014, they have conducted another study. In that 18 fingerprints they have examined, one was false positive. But it is not possible to rely completely on fingerprint examination. So since according to section 349, we have included fingerprint as well in this category, without having a scientific basis of complete accuracy of fingerprint examination. And there is another error also. This is close non-matches error. Actually, when you are getting two different fingerprints from two different sources, this fingerprint examiner will be having always will be having a tendency to find out similarity between these two fingerprints. So they will be having a bias to make it similar. So this close non-match error is very high in nature. It is 28.171%. And another concern is with respect to uniqueness of the fingerprint. So the one of the main fundamental idea of fingerprint examination itself is it is unique. Every individual will be having a unique fingerprint. But the problem is that there is no scientific data or there is no study which is specifically mentioning or substantiating that all the fingerprints are unique in nature. So without proper scientific studies, it will be difficult to rely on the fingerprint completely. And another issue is with respect to contextual bias. Actually, if the fingerprint examiner, if he is having any other information with regards to the crime, then there is always a possibility that he will have a bias when he is examining this fingerprint examination. So there are a lot of problems with respect to accuracy of the fingerprint. And we don't have a specific statistical study with respect to the uniqueness as well. So since the accuracy and the uniqueness is in question, without having a substantial study, will it be fine to have or collect the person's fingerprint by for a criminal investigation purpose? Will it cause a serious concern over the person's privacy? A lot of other constitutional concerns as well. So this is one challenge. We have to, the legislature or the parliamentarians has to analyze the problem of expanding the scope of 311A as well. Now, when it comes to voice analysis, this is another feature of 349. Now, a voice analysis can be done by forensic experts or the experts of voice analysis. But when it comes to voice analysis or voice comparison also, there are a lot of concerns. Like the voice will be different for the same individual according to linguistic population and the condition of voice recording and the storage, transmission. So all this will create confusion when they are comparing two voices. And another is like a single individual, that person himself will give different kind of voices depending upon the language, accent or dialect, speaking style or their emotional or physical condition. And there are no studies with respect to the uniqueness of voice sample as well. So until a scientific foundation is there with respect to voice analysis, it will be very difficult to implement those kind of provision in for criminal adjudication, or incorporating that in section 349 will cause lot of concerns since we don't have a scientific foundation. The studies are going on, but it does not prove the uniqueness or whether voice analysis have been tested. Will it be possible to identify the uniqueness of different voices? So those kind of studies are conducting, but it is not completed. So it will also cause certain concerns. If there is any doubt, you can ask. Otherwise, I will continue with the another important concern. Yes.
Hello, ma'am.
Yes. Yes.
Can
Yes.
I ask a question?
Yeah.
Yeah,
Sure. Sure.
ma'am. You raised so many challenges in the case of forensic science
Yes.
involved in the detection of the case.
Yes.
So, what is the new hope of AI, artificial intelligence, in this forensic science?
Actually, use of AI and forensic science, in a very basic stage. The use of AI in legal framework itself is very nascent stage. So, especially with respect to cyber forensic, I think that now the studies are going on with respect to AI and all. Other traditional forensic science tools, we are not using AI as such, especially in Indian context. So, it may give a greater advantage in immediate future. But as of now, we have not explored the scope of AI in forensic science field.
Thank you so much. Thank you
Yes.
so much.
Yes, Saroj, do you have any doubt?
Yes, ma'am. Good evening, ma'am.
Yes.
Ma'am,
Good
I
evening.
just want to ask you that means you have
Hmm.
said that government forensic experts as well as the private forensic experts are also included in the criminal investigations case. But
Yes.
ma'am, means the type
Hmm.
of case which will be
Ah.
governed by the government one and which will be means it will be
Hmm.
like in which part which will be mean, whom will be included.
Okay. Actually, every cases, you don't need to divide or classify the cases into the government case or the private cases. There is no division or classification in such way. Here, every cases, every offenses which is punishable more than 7 years or 7 years. There, they have mentioned investigation officer. Investigation officer will be always a government officer, right? Police officer. So he can take the assistance of forensic expert. They have not mentioned whether it is private forensic expert or government forensic expert. It can be both. That is implied from the section. So in almost all the cases, both private and government forensic expert can assist investigation officer in crime scene. That's what the section meant for.
Okay, ma'am.
Yes.
Another doubt was that if there is any kind of tampering in
Hmm.
case of forensic evidences, then is there
Hmm.
any kind of separate sections for it or the same statute for normal tampering of evidence as well?
There is no separate statute for identifying tampering of evidences. But when, especially traditional forensic evidences like blood samples, semen, it will be very difficult to identify whether it has tampered or not. Only one thing the court will be analyzing the process, how they have collected, how they have preserved, how they have examined the forensic evidence. If they are finding out any irregularity in that, then obviously they are not going to make it admissible. But when it comes to cyber forensic or electronic or digital evidence, it is always possible to have analyzed whether the tampering has happened or not. For that, for confirming it, we have a provision also under Bharatiya Sakshi Adhiniyam section 63. If you are producing a digital evidence or electronic evidence, one forensic expert has to acknowledge that there is no tampering has happened with respect to this electronic or digital evidence. There is a separate provision for that. Apart from any other evidences, we don't have any statute or statutory guideline for. Okay. Now, whether my voice is clear, and we.
Yes, ma'am, your voice is clear. I
Yeah.
added question on the chat box.
Okay. I think Saroj, is it clear for you?
Yes, ma'am. Yes, ma'am. Yes, ma'am. Thank you, ma'am.
Okay. Yes. Now, is there any questions? Then, yeah.
Good evening, ma'am.
Good evening. Good evening, Arham. Yes.
Am I audible, ma'am?
Yes, you are
Am I
audible.
audible?
You are audible.
Ma'am, just like you told, the forensic experts can take the handwriting of anyone who is not actually involved in that case. Ma'am,
Yes.
would it need to violate the right to privacy of that person?
Yes.
Ma'am,
Yes.
because
Mhm.
so,
Yeah.
ma'am, what will be the ma'am if someone comes to me and
Ah.
asks me a handwriting, and
Mm.
according to me, they are not giving a valid reason
Yes.
or reasonable reason. So
Mm.
what should be the what should I have to do
Ah.
in such
Actually,
cases?
see, this is one of the problem. We are unable to find out a solution. This is one of the
Okay.
challenge because of the expansion of 311A. Even if you are not connected with the crime, then also if the magistrate who has ordered for collecting your handwriting or fingerprint, whatever it is, you have to give. So the only option you are having is to ask for a clear justification, otherwise challenge this before the court based on your fundamental right of privacy and fundamental right under Article 20, Clause 3.
Okay, ma'am.
You don't need to give evidence, self-incriminatory evidences. So this is the
And
only solution you are having as of now. That is why I have raised this as a challenge.
okay, ma'am. Ma'am, one more thing.
Yeah.
Just like you have asked forensic experts,
Hmm.
ma'am, just say for example, if a murder is committed
Yes.
and ma'am, a forensic expert signs, ma'am, what will be the maximum duration for him to investigate a crime scene?
Actually, the golden principle of crime scene investigation is that protect the crime scene as early as possible, and as early as possible, how much early you can access and collect the evidence from the crime scene, that will be the best. There is no clear protocol for that. You should access the crime scene like in this particular time, you should not access it later. It is not like that. There is no clear guideline or time period prescribed, but the golden rule, fundamental principle of forensic sciences, there is one another
Ma'am, but
principle. Yeah.
ma'am, but if the time limit is not defined, then anybody can easily tamper with those evidences.
If the time limit has not been, they have not been mentioned that, then it is always possible that someone else will enter into the crime scene. So it is the duty of investigation officer to protect the
Okay.
crime scene whenever he is aware about that crime scene or the crime. So if he has failed to do that, then that question can raise before the court when this all the trial proceeding is happening. Apart from that, we are not making it mandatory. Investigation officer has to go to the crime scene immediately. But this is the standard procedure they are following.
Thank you, ma'am. Thank you.
Any other doubt? If there is no other sensations, I think we can move forward, right? Yeah. Okay.
Yes, ma'am.
Yes. Okay. Now, lack of validation of procedure in Indian forensic science lab. Actually, we don't have that much expertise in voice analysis because it might face lot of challenges with related to reliability, validity, and correct application in individual cases. And we don't have standardized procedure also. Every forensic science lab will be having different procedure, and they don't have a working procedure manual. Since they are not having a standardized working procedure manual, when they are analyzing fingerprint and voice analysis, it will be according to their discretion. So without having a proper working procedure manual, will it be good enough to implement those kind of provisions? This is another concern. Okay. And nobody is sure about if your fingerprint has been collected by investigation officer and it has been examined in the forensic science laboratory, whether that will be safe enough or not. Because all your biological information can be extracted by the investigation officers. So what if those information get leaked? There is no potential or comprehensive safety or concerns or safety measures for protecting your biological samples. So this will cause another concern, because there are a lot of instances where, like, if somebody else is getting your DNA, or for example, if a foreign pharmaceutical company, they wanted to know what are the possible diseases of this particular ethnicity. By having their DNA data, it will be easy for them to find out what all future diseases this ethnicity will be having. So they will make medicine according to that. They will give insurance policies only for the person who will not be having the possibility of having this kind of diseases. For example, if some pharmaceutical company, if they get your DNA data or blood sample, something like that, they can easily analyze whether there is a possibility of cancer or those kind of diseases. If they understood that, what if they are denying your health insurance policy? So safety of your biological samples and biological information is a serious concern. But we don't have a great consideration for that in Indian legal framework. Only after Puttasamy case, we have given some importance to right to privacy as well. There it has specifically mentioned about the privacy of biological data they are collecting through Aadhaar and all. This is another issue. Now, another serious concern, this is another change as well. Actually, whenever the forensic expert is giving certain testimony before the court, or if they are giving their report, for example, if a medical practitioner is giving his postmortem report to the court, generally the court will rely only on that report after cross-examine that expert. But now under section 329, we have excluded certain forensic experts from cross-examination or verifying how they have created, how they have reached into this result or this report, how they have collected, examined, analyzed this evidence. Nobody can question that. You can challenge that only in one stage, that in pre-trial stage, when there is the forensic experts documents, when the court is taking that if you are having any confusion, opposite party, generally the opposite party defense is having any confusion with regards to forensic evidence, forensic report which was submitted by the forensic expert, at that time they can challenge. But most of the time, most of the forensic evidences will reach after trial stage or during trial stage. So there we are restricting the option of challenging those kind of forensic expert reports. The court is, without having a judicial scrutiny, they are taking this forensic expert document into consideration. This will cause a serious concern, because if there is a doubt with respect to how the forensic expert has analyzed, how he has reached into this decision, this result, if there is no, if they don't have a substantial explanation, then why would we believe that particular report? But here, by incorporating section 329, the court is completely excluding that option. Only in one stage you can challenge, that is pre-trial stage. If you are unable to challenge in that stage, it will be impossible to challenge the document of forensic expert. And this benefit is available only for certain high dignitaries of forensic science. But what is the criteria for making that demarcation? They have not mentioned that. This is one concern, and here the court or the legislation has to rethink about this section, because without having a judicial scrutiny, it will be difficult to believe the report of the forensic experts. And it is contradictory to section 339 of BSA as well, expert testimony. Because there the Bharatiya Sakshi Adhiniyam is allowing, whenever there is an expert testimony, you can always challenge or ask, contradict the expert opinion if you are having the doubt. Defense will always be getting that option. But according to this new 329, section 329, we are not having that option also. That is another serious concern. Okay, this I have already mentioned. You can, I will be sending this presentation to you. You can read this for further details. So if there is any doubt with respect to BNSS and the application of forensic science, you can ask. Yes, Himanshu, yes.
Ma'am, first of all, good evening.
Good evening, good evening.
Ma'am, that section 329 you are talking about, ma'am, I
Yes.
think, ma'am, what do you think, it is unconstitutional or some
It
in
is
what
not-
way? It is also against principle of natural justice,
Yes,
because it's not challenging at that point of time.
because it has some concerns. The one of the main problem is that it is constitutionality. We don't need to challenge the constitutionality of that. Rather than we can challenge that by stating the natural justice principle, because here the other side or
Yeah.
if you are having any doubt with respect to this forensic expert's opinion, you should obviously get a chance to question that, right? But here
Yes.
you are getting a chance, but very restricted chance. If you are in defense, you can challenge that only in the stage, pre-trial stage. But post-trial or during the trial, it is not possible. And if the court themselves is having a doubt with respect to the document or the evidence the forensic expert is submitting, they will submit a report. If the court themselves is having an option, then also it is not possible to cross-examine the forensic expert or summon that person, forensic expert, to the court and ask questions. It is only possible when the defense is having some confusion regarding the genuineness of the report during the pre-trial stage. So this is highly restrictive in nature. We are not having an option of challenging it. Yes, Shreya?
Thank you, ma'am.
Yeah. Thank you, Himanshu.
Good evening, ma'am.
Good evening.
Ma'am, if I'm not mistaken, or I am hoping I have not missed this point,
Yes.
ma'am, I just want to know that the fingerprints and other evidence, like other things, are considered evidences under the forensic science in legal practice. Ma'am, do we consider handwriting to be under this provision?
Yes, we are considering handwriting as well.
Okay.
It is possible to take signature, handwriting, and voice sample and fingerprint as of now.
Yes, I'm sorry, I might have.
Yeah, it is there. It
missed
was there earlier also, handwriting. And for
Okay.
handwriting, yeah, it was not only the forensic expert can give or analyze the handwriting. Handwriting can be analyzed by a person who is acquaintance with that. Maybe Shreya's handwriting might be knowing by your friend. She can also acknowledge with respect to your handwriting. Or the court. Sometimes the court will ask the person to come and write before them, the judge. That is another option with respect to handwriting. So it is not exclusively for forensic experts. Yes, I think it is
Okay.
clear, right? Yeah.
Yes, ma'am, it is clear.
Okay. Can we move forward? Yes.
Yes, ma'am. Yes.
Okay, so now let us have a discussion with regards to the role of forensic science in Bharatiya Sakshi Adhiniyam. This is our Indian Evidence Act, okay? So here, both Indian Evidence Act and Bharatiya Sakshi Adhiniyam, they are giving like a particular provision for forensic expert. As I have already discussed that every testimonies which has given by an expert will be considered as relevant. Court will take this testimony into consideration. For that, the person has to be an expert. Expert means he has to be an expert of foreign law or science, art, or any other field, or identity of handwriting, finger impression. Okay. Or if a person who is specially skilled in science, art, or any of the field, then that person, we will call that person as expert. Okay. So here they have mentioned only specially skilled. But what is that? How we will determine whether the person is having a special skill in this area? We don't have guidelines or criteria for that. This is one concern revolving around both 45 and section 39 of DSA. So here, an examiner of electronic evidence will also consider as expert. Okay. So here, this is the important question. Who is an expert? Who is an expert? They have not given a definition under section 45 or 39. They have given certain examples. A person who is having specialized skill in art, science, foreign law, they are called as expert. So to understand who is expert in a better way, let us examine some of the cases. How Indian jurisdiction, Indian legal system, how the judges are considering a person as expert or not. Here in one of the case, which had happened in 1974, Chand Batra versus State of UP, there the Supreme Court had accepted that an excise inspector, he is having expertise in identification of illicit liquor. He might not be having a degree, official degree for, or maybe some license for, or acknowledgement from somewhere that he is an expert in identifying illicit liquor or what is the composition of liquor. But only by experience he is getting this expertise. So court has even considered an excise inspector as also an expert in this particular case. And another case which is very important, State of Himachal Pradesh versus Jailal, 1999 Supreme Court. Here the Supreme Court has defined what is mean by specially skilled, because our section 45 and 39, it was silent on who is this specially skilled. What is specially skilled? So here the court has given a criteria for that. A person can be said as a specially skilled only when he is having a special study or acquired a special experience in that particular area. Only when then we can say that person is specially skilled. He should have either he should have a special study in that particular area or he should have a special experience. And the court has further held expert is not just a witness, or he is not an advisory, he is not having an advisory character. It is the duty of the expert to provide the judge with the necessary scientific criteria to test the accuracy of their expert conclusion. How they have reached to that conclusion? They have to give scientific criteria. There the importance of forensic evidences. In forensic evidences, we will only be using scientific method to elucidate evidences, right? So, only a person will be called as an expert when he is explaining how he has reached into the conclusion, what are the scientific criteria he has used. This was mentioned in State of Himachal Pradesh versus Jailal. Another important case that is in 2009, Ramesh Chandra Agarwal versus Regency Hospital Limited. There the court has devised 3 criteria for identifying who is an expert. These 3 criteria are: it should be a recognized field of expertise. They have mentioned art, science, foreign law. In art and science, foreign law itself, there will be various fields. So first of all, generally we should acknowledge that or recognize that this particular field is a field of expertise. It is having a possibility to do an expertise in this particular. This is the first condition. And the second is, Evidence is based on reliable principle. Here, the reliable principle means that whatever evidences they are elucidating should be based on scientific principles. It should not be based on their subjective analysis. The next is expert is a qualified in that discipline. Wherever he is having that expertise, he should have the sufficient qualification in that discipline. These are some of the criteria we have elucidated, or the court has devised a mechanism, but till now, even after the introduction of BSA, we have not defined who is an expert in a very proper way. And specialized knowledge he should have. They will assist the court for delivering the justice, and they will consider only relevant facts. Irrelevant facts, they will not be giving any opinion with regards to irrelevant facts. These are some of the points. And in one of the very famous case, the Supreme Court has warned Rahul versus State of NCT of Delhi. The Supreme Court has rejected the DNA evidence due to lower court's failure to scrutinize the expert's methodology. Here, the lower court, they have taken the DNA evidence into consideration, but they have failed to analyze in what way the expert has analyzed the DNA evidence and how he has reached into the decision. Only because of that, the higher court, Supreme Court, has rejected that DNA evidence. Because it is very important to know the expert methodology, how he has reached into this conclusion. Now, when it comes to admissibility of electronic evidence and digital evidence under BSA, this is another area where there were a lot of confusions with respect to admissibility of electronic and digital evidences. Okay. And how it is having importance in forensic science, because we are having another discipline, another variant, cyber forensics. Now it is almost very much evident that almost all the criminal cases, there is a presence of electronic or digital evidences. Most of the crimes are getting resolved through analyzing the electronic devices they are using or electronic evidences. So under Bharatiya Sakshya Adhiniyam, we have made a comprehensive idea with respect to how we should admit electronic evidence or digital evidence. Let us see that. But in Indian Evidence Act, which was absent, because in Indian Evidence Act, there was a participant, he has asked me a question with respect to tampering of evidence. This tampering of evidence is highly possible in digital and electronic evidences. So, in every other evidences also it is possible, but electronic and digital evidence are more prone to that. So, the best principle, Indian Evidence Act or Law of Evidence in India is having a principle that best evidence rule. Whenever you are submitting any kind of evidence before the court of law, you should always try to produce the primary evidence. Whatever evidences you are having in an original form, you should produce that before the court. This is applicable with respect to, like, if I can give an example, if you are having a originally written letter in your hand and you are having a copy of that letter, court will always ask you to produce the original handwritten letter rather than producing the copy. If you are not having original handwritten letter, then only the court will allow, with a lot of conditions, you to submit the copy of the originally handwritten evidence. That took the lot of conditions. This copy of the originally handwritten notice or letter is not a secondary evidence. Okay. So the rule is you should always submit primary evidence. The same will be applicable with the electronic evidences as well as digital evidences. You should try to submit primary electronic evidence before the court of law. Will it be possible to produce primary evidences, electronic or digital evidence in court of law always? Will it be possible? Most of the time it is not possible, right? For example, if you are having some evidences, electronic or digital evidences in a CCTV, for example, in your hostel, some kind of crime has happened and you are having a CCTV footage of that. But you know how CCTV will work, right? It will capture and simultaneously it will record. If you are removing the recording from that, then obviously the next moment, the next footage will not be getting recorded. So it is a problematic situation. So whatever happened after removing the recording, it will not get recorded. So for that, basically in CCTV footages, what will happen? We will not produce original evidence. We will copy the footage to the another device that will only get produced before the court of law. Another example. If you are having a computer system in your or a desktop you are having, and there are a lot of evidences, lot of data you are having in the desktop, which is useful for a criminal investigation or any kind of offense. So there, the court is asking you to submit original evidence, original data, but that original data is in your desktop. It is not possible to produce this desktop before the court of law, right? So how will you produce? You will copy that particular data to another portable device and you will produce. But whenever the moment you are copying that device, the data, it will become secondary. So it is nearly impossible in substantial cases to produce original or primary electronic or digital evidence. You have to copy that always. But whenever you are copying some electronic or digital evidence, it is always possible to get tampered because it will be very easy to tamper electronic or digital data. The hash value of that electronic or digital data will get tampered. So it is almost sure that it is almost we have to make, the court has to make sure that you are producing a secondary electronic data without tampering. For that, the court is making mandatory whenever you are submitting an secondary electronic data, you have to produce it along with a certificate. That certificate will be produced by the person who is having the possession of that particular device. Okay. If I was possessed a particular device, then I have to produce that before the court of law. I have to produce that certificate. But this provision was there in the Indian Evidence Act as well for preventing the tampering of evidences. But after, there were several concerns with respect to this because in Indian Evidence Act, the Act was silent about what is primary electronic evidence. Act was not giving any explanation for that. So it will be very difficult for a person to understand whether this electronic evidence is primary or secondary. So most of the time, the people will think that it is primary, it is original in nature. They will submit that before the court without any certificate. Then the court will reject that. So this has happened several times. And there were several concerns that is it mandatory to submit certificate with along with all the electronic evidence? That was another question. So resolving all these questions, addressing all these issues, under BSA, we had given examples for what is primary electronic or digital evidence. We have given 5 explanations for it. I have attached that in the screen with the PPT. You can analyze that. Okay. I am not getting into the detail of that. You just have to understand this much. Now we are having a guideline. We are having examples for what is primary electronic evidence. So something which is coming under primary electronic evidence, you can submit it without certificate. But if it is not coming under any of this, you should understand that it is secondary. So you should submit it with a certificate. Now it is not on certificate. It is 2 certificates. Yes, Aisha, you are having some doubt. Can you tell me?
Good evening, ma'am. Ma'am, I just asked here, firstly. Ma'am, my doubt was with regard to the definition of it is whether it is the definition of primary evidence is specifically electronic evidence or as whole.
No. Primary, we don't have the definition for primary evidence. Indian Evidence Act is completely silent on that. Primary evidence means different cases has given certain guideline conditions for considering this as primary. Primary means something which is original. Arjun Pandit Rao case has specifically mentioned primary means something original. And your question was with respect to whether this is only applicable to electronic or digital
Electronic,
evidence,
yes,
right?
ma'am.
No, it's applicable for all the evidences,
Okay.
all kind of evidences. I have
Okay.
given an example of a letter, right?
Yes, ma'am. Yes, ma'am.
Yeah. So it is applicable for all the evidences, but the concerns was with respect to electronic or digital evidence. Because it is very difficult to determine what is primary electronic evidence. Because we are not having, or investigation officer will not be having that much expertise with respect to it.
Yes, ma'am. I got it. Okay.
Okay. For that, they have given for examples, for explanations to understand what is primary electronic evidence. Now, all the evidence which is not primary in nature, that is secondary electronic evidence, has to be submitted along with a certificate under section 63. What is that certificate? 2 certificates. One certificate is by a person who is originally holding the possession of that particular evidence. He has to certify this evidence has not been tampered. What is the make, model, what is the information is in that particular evidence. That format of certificate I have attached. I will show that as well. And then the second certificate is by a cyber forensic expert. He has to acknowledge that this evidence, secondary evidence, has not been tampered. This contains all the details of original evidence. He has to acknowledge that as well. Without these 2 certificates, secondary electronic evidence will not be. This is one of the important change which happened with the Bharatiya Sakshi Adhikam in cyber forensic evidence. Okay. I'll show you the format of certificate. These are some of the examples of primary electronic evidence. Okay. Explanation you can see. Section 57 of explanation. Storage occurs simultaneously or sequentially in multiple files, email threads, backup, archives, websites. If I give an example for this, storage occurs simultaneously. What does it mean? CCTV is capturing something and storing it at the same time. It is not happening in a different, it's not happening one after another. Storing at the same time, capturing at the same time, storing at the same time. Those kind of evidences can be considered as primary. Another is produced from a custody, proper custody. For example, if somebody want to get my call records and I am using a Vodafone SIM, who is the proper custodian for that? I am not the proper custodian. The telecom company, Vodafone, will give you the call log of my phone. So if the investigation officer is producing that from the Vodafone telecom company, that will consider as the proper custody. That will also consider as origin. Okay. Another example, video recording simultaneously stored and transmitted or broadcast. For example, some live streaming is happening. If there is a cricket match, if it is happening, live streaming will happen at some other places, right? So both will consider as primary evidences. So these are some of the examples. You can read further with respect to this. This is one of the very important case in 2020, Arjun Pandit Rao case. Arjun Pandit Rao versus Kailash. It has specifically mentioned that it is very important to produce. If you are producing secondary electronic evidence, it is very important to produce it with a certificate. Okay. I'll show you the certificate, format of certificate. See, this is the first certificate to be filled by the party. Party means who is having the possession of that device. all the details, name, where he is residing, and what is that particular computer, whether it is computer, a mobile, flash drive, what is that device, and make and model of the device, color of the device, serial number of the device, and if there is any specific MAC ID, UID ID, or something like that, all this information has to be given. Okay. And which is owned, maintained, and managed, operated by me. That if I am having the possession of that, then I have to mention I own, maintain, manage, and operated this. And hash value of that particular evidence by using this algorithms. Okay. So these are the name and signature, all these details. And another certificate to be filled by the expert. Expert should also give all these details, hash value, all these things. Okay. I think it is clear, right? Is there any doubt, confusions? If it is not there, then we will discuss another important aspect, that is with respect to Criminal Identification, Criminal Procedure Identification Act 2022. You all might be knowing about this because this was one of the most criticized act, which was causing a lot of constitutional concerns. According to this act, investigation officers can collect, process, storage, preserve, disseminate, and destruction of any kind of measurements of a particular person. What is mean by measurements? Let us see what is measurement. Measurements has been defined under section 2, clause 1, clause B. It include fingerprint, palm print, footprint, photograph, iris, retina scan, biological sample, and behavioral attributes. Behavioral attributes. So an investigation officer can process, preserve, store all this information from a person. Okay. And it includes biological evidences like blood, semen, swab, DNA, all this will include under this. Okay. And from which person this evidences can be collected? It cannot be collected from random person. If a person who is convicted of a crime, from that person, the investigation officer can collect. And if a person who is just arrested, he is not convicted, but if he is arrested, then also from that person. And any detainee of preventive detention laws, from there also we can collect that. And any person directed by the magistrate, if the magistrate feels that the investigation officer should collect information from any person who is related to this investigation, that can also be done. But that person might not be formally arrested. Then also from that person you can collect. And from minors also, special provisions for collecting this kind of evidences from the Juveniles and Vulnerable Groups Act. What is the problem with this act? What do you think? Whether it is causing any serious concerns? It is causing a lot of concerns, right? Because basically this collection preservation is for 90 years. What all possible misuse can happen by collecting, processing, and preserving this data? And we are not sure about one thing, whether this data will get protected or not. What if there is a possibility of leakage of this data? And what about the privacy concerns of different individuals? What about the privacy concerns of not only those individuals whose data are collected, their family members? Because DNA will be shared in the entire family, right? All the information of that family member will also get preserved, processed by this criminal identification. These are causing serious concern. And it is violative of Article 20, Clause 3. This is one of the most important constitutional provisions. This is protecting you from giving self-incriminatory evidences. It is like the court or you shall not be compelled to be a witness against yourself. So by giving this kind of evidences, you are getting compelled to give evidence against yourself. So it is against Article 20 clause 3 as, and it is against Article 14 as. And there are no proper guidelines how they will be collecting this data, how much time they will be preserving this data, for what purpose they will be using this data, on what kind of crimes they will use this data, they will exercise this provision. No guidelines, no clarity. It's causing a serious privacy concern. You have to think about that. Yes. Lack of purpose limitation, scientific validity issues, and administrative challenges. Lot of other like challenges are there with unregulated database. We don't know where they will store this data or when they will delete this data, timeline possible, mass surveillance will be possible, lot of right violations will occur by this. Okay. Now the last and the most important application of forensic science is one of the advanced technology like narco analysis and narco analysis. Like, yes, Jayalakshmi, do you have any doubts?
No, ma'am.
Okay, okay, fine. Yes, 3 technologies: narco, lie detector, brain mapping. This is also causing a serious concern. Basically, here I am discussing certain concerns when it comes to application of forensic science technology in legal framework. This is what is the concern with respect to narco and polygraph and lie detector. In narco analysis, actually how they are doing this, they will be injecting a particular drug, basically sodium panther. They will inject a particular drug to the accused person, and accused person will be in a trance position. He will not be having control over his cognitive behavior or his like subconscious mind. So whenever the investigation officer or the narco analysis expert is asking any question related to the crime, he will be telling the truth. Basically, he will be telling the truth. That is narco analysis test. But narco analysis is having a problem. Basically, accused is giving evidence against himself. That is against Article 20 clause 3. No one shall be compelled to give evidence against himself. That is our fundamental right. Every accused, it is not only restricted to the citizens. Every person is having this right under Article 20 clause 3, right against self-incrimination. But by exercising this narco analysis, they are infringing their right. So this constitutional question has raised before Selvi versus State of Karnataka, one of the landmark judgment. There the court has mentioned no one should be compelled. So if it is not possible to do narco analysis by compulsion, if they are voluntarily ready for that, it is very much fine. It is constitutional. But if they are not ready for that, it is not possible to exercise this particular test. The same will be applicable with lie detector and brain mapping as well, because it is against Article 20 clause 3. This is one of the serious concerns with regards to latest psychological texts in forensic science. Okay. Yes. I think I am done with most of the provisions related to forensic science in Indian context. If you are having any doubts regarding any of this discussion, you can ask right now.